All right, good people. Oh my God. Finally, guys, finally, the defense team has a win in the motions. Finally. Oh my God. And let me tell you something. It took the judge a whole bunch of tooth pulling for him to even give them that win. Because he's even giving them, if you could bring in those original pictures, I'll go back and look at my decision and see if there's something else can happen. Oh my God. It took a long time for him to even give them this win. So shout out to Attorney Sharp for winning Shannon Stillwell's motion to suppress. So I'm gonna play the judge's decision for you guys. It's gonna be a little bit, it took the judge a little long because it was like, but they had no choice because it's law. It was law. So I'm hoping folks come on in here. Come on in. This is what we need to have. This is a win. This is a win. This is a win. Let me see if Shannon's wife. There she go. Miss Tasha, could you call that to everybody so I could just play this? So you guys gotta win, y'all. You gotta win this today. And guess what? I didn't even know it because I was recording and I wasn't paying attention because I was downstairs with the Trump stuff. So I was doing two cases at the same time and I didn't get a I said, you know what, I'll go back and listen to it because I know already I was recording the one with the YSL. But you can hear the judge very clear and while he's making his decision, his ruling on it. So today they had the final individual who testified. That's not the important thing. The important thing is that they got a win, and you're gonna hear the judge tell the reason why he has to stand with the defense on that particular motion. So, Mr. Stillwell, Shannon Stillwell, has received a win. A win, y'all. Finally, the defense got a win. And I'm going to play the judge. Guys, go share this. Share this with everybody. Finally got a win. It's been a tough road, but they got a win. And tomorrow, Mr. Steele will be up on for his motion. Yeah. Tasha, those prayers been working, girl. Those prayers have been working. Where's Taisha? Where's everybody? Tell everybody come on in the chat. You guys, it's time for y'all to celebrate. Celebrate. Celebrate at each stage. But I'm gonna go ahead and play this. Y'all folks are just too much. Where's she at? The motion about witnesses. No, it's not the motions of no. This is the motion to suppress. This one is extremely important. This one is a very important motion to get. It's that witness lineup that has been thrown out so far. The witness lineup that they did with the man, that has been thrown out. And the judge is going to give the reason why it's been suppressed, meaning suppressed, take out, they can't bring it into the trial. So that's a win. Oh, you're talking about tomorrow. That's not the witness list tomorrow. It's item number 7, motion number 7. I'm gonna go back and look at what motion number 7 is. But right now, let's take one day at a time. We're talking about this one right here. All right, so all those who want to know what this is all about, this is the motion for Shannon Stillwell, the video lineup of where they picked them out of the lineup, that one, the witness identifying him, Remember the one where we were talking when I was telling you guys that Shannon Stillwell is the only one with a tank top, white tank top. Everybody else had on dark clothes. The video was very grainy. The background, his background had one color. Everybody else had the same color. Remember that? This is the one that is being thrown out. Well, right now at this present time, unless they can bring the original. Because remember, the original supposedly disappeared. It's somehow, and the only thing they're relying on is the video. And then there was some suggestion done how to pick Stillwell. Remember, they held the picture a long time. He kept switching over to different pictures. He kept coming back to Stillwell's picture. Well, I guess you guys didn't know that because you're not looking at the video, but that's what happened. So I'm gonna go ahead and I'm going to play the judge's decision. Okay, gonna go ahead and start it right now, and you guys can hear real clear on this one. He's gonna start it off. Got to take your wins where you can get them. That's right, Sierra. So shout out to Attorney Shaw and Attorney Max for their win. They got a win today. They got a win. So you guys just bear with me. I'm trying to pull it up. And this is, I'm playing it right now. They haven't started yet. The judge is going to come in and he's going to give his reason. All right, guys. It's getting ready to start for a few minutes, and I should have hold on a second. Just 1 second. It's gonna play in a few minutes. Just 1 second. It's one of the detective asked the other detective to step out the room during the time. Yeah, that's the one that I was talking about. Yes, from yesterday. Yes. It's gonna come on in a second, y'all. Give me a few minutes. I'm waiting for it to come on. They're coming in now. I know. Here come the judge now. There we go. All right, thank you, Judge. All right, he's about to give his decision, his ruling. I already gave you the answer, but I just want you to hear the details. All right, all those that's coming in, the defense team has a win, and that win is from a motion that was submitted by um, Shannon Steele, Shannon Jackson's attorneys, Mr. Shaw and Mr. Matt. They have won the motion to suppress this the lineup evidence. So because of the bias and the persuasion that was done during the witness photo lineup, and the judge is going to give you detailed information on that. Guys, please share this. This is very important, because now you didn't have a camera person in the courtroom, and I'm playing exactly what was done. The judge is just trying to prepare himself. He's pulling up the information. Hey, Annie. You heard it here, y'all. Exclusive coverage. Yeah, it's really exclusive for real, Annie. For real, it's exclusive because camera people are not even there. But they were at the Trump thing.
Okay, in ruling on the motion to suppress the identification, it was saw on March the 17th of 2017. The court has heard testimony from several witnesses, including but not limited to Deputy DA Michael Sprinkle, Detective Thorpe, Investigator Martin, and in Stage 3, in particular, the videotape of that particular interview, as well as...
I love you too. Thank you, Annie.
as well as States 1, Stage 2, mentioned Stage 3, Stage 4. Stage 3 also has an audio portion as well, reports that heard. Stage 6, Stage 7, Stage 8, Stage 9, the interview transcript that has been marked for identification. Stage 10, 11, 12, and 13, which are photographs, or I should say screen grabs of their incident of the video in Stage 3. Further, the court has learned from through the testimony that Coletta Thomas, the mother of Donovan Thomas, told Mr. A.D. Sprinkle the existence of this possible witness named Car Wash. And I've heard the testimony of A.D. Sprinkle identifying this man as Sammy Davis. Sammy Davis is the person that was interviewed on Stage 3. The court has seen the video of the March 17th interview, wherein A.D. Sprinkle, Detective Thorpe, and Investigator Martin interviewed Sammy Davis at APD headquarters. Sammy Davis describes what happened. Here's a description of the passenger in the second car, and is shown 3 photo lineups. And the third lineup contains, of course, Mr. Shannon Stillwell and 5 fillers. No identification is made, and it said that Davis hovers. I can look at the video and just show that Davis hovers over a still photo, says he looks familiar from the Mechanicsville area. On March the 20th of 2017, A.D. Sprinkle, Detective Thorpe, and Officer Garner interviewed Sammy Davis at the jail. Sammy Davis references the previous photos shown that are fairly contained within stage 3, and says that the man with the tattoos and the white tank top was the passenger in the car. I'll note also in looking at stage 3, it is the videotape of that particular interview. It is grainy and of limited assistance in helping determine whether or not in the test for suppression, is the lineup impermissibly suggested. The court, in determining that issue, has to rely upon the case law and the state statutes in regards to lineups. In particular, the court has heard arguments, and of course, the seminal case is the Vickers, Neal versus Vickers case, which is the United States Supreme Court case, which covers the issues of whether or not there is the test as to impermissibility or impermissibly suggested. The court is required to go through 2 steps. First, determine was the photo lineup impermissibly suggested, and then if it says yes, I go on to, if so, is there a substantial risk of irreparable misidentification? So, in taking a look at that, there are some Georgia cases that are helpful in this analysis, but let me give the citation for Neal versus Vickers. That's 409 U.S. 188, 1972.
He's taking his time with this one, y'all. There's a win, Danny. There's a win. It seemed like it was hard for him to give them the win.
Okay. In taking a look at the case law in Georgia, our Supreme Court in Harris versus the state versus Harris, I should say, decided May 16, 2023.
Yes.
16, Georgia.
Yes, Doug.
Doug
Adele.
Our Supreme Court reviews the trial court's ruling on a motion to suppress identification evidence for abuse of discretion. Evidence of an out-of-court identification violates due process and is inadmissible at trial if the identification procedure so impressively suggested that it could result in substantial likelihood of misidentification. Identification procedures unduly suggested when it leads the witness to virtually inevitably identification of the defendant as the perpetrator and is equivalent to the authorities telling the witness, this is our suspect. And even when an out-of-court identification procedure was impermissibly suggested, the identification may be excluded only if a substantial likelihood of misidentification exists. Factors for evaluating the likelihood of irreparable misidentification due to an impermissibly suggested out-of-court identification procedure include: 1, a witness's opportunity to view the accused at the time of the crime; 2, the witness's degree of attention; 3, the accuracy of the witness's prior description of the accused; 4, the witness's level of certainty at the confrontation; and 5, the length of time between the crime and the confrontation. Whether a witness knows the defendant is a critical factor in determining the reliability of an out-of-court procedure. The court has also taken into account OCGA 17-20-2B2, enacted, I believe, in 2016, wherein it references no later than July 1st of 2016, and this interview occurred after 2016. Any law enforcement agency that conducts live lineups, photo lineups, or show-ups shall adopt written policies for such, using such procedures for the purpose of determining whether a witness identifies someone as the perpetrator of the alleged crime. Live lineup, photo lineup, show-up policies shall include the following: with respect to a live lineup, having an individual who does not know the identity of the suspect conduct the live procedure. With respect to a photo lineup, having an individual who does not know the identity of the suspect conduct the photo lineup, or B, who knows the identity of the suspect, use a procedure in which photographs are placed in folders, randomly shuffled, and then presented to the witness so the individual conducting such procedure cannot physically see which photograph is being viewed by the witness until the procedure is complete. Providing the witness with instruction that the perpetrator of the alleged crime may or may not be present in the live lineup or photo lineup. Composing a live lineup or photo lineup so that the fillers generally resemble the witness's description of the perpetrator of the alleged crime. Using a minimum of 4 fillers in a live lineup and a minimum of 5 fillers in a photo lineup, and having the individuals conducting a live lineup, photo lineup, or show up seek and document at the time of an identification of an individual photograph is made in the witness's own words without necessarily referencing a numeric or percentage standard, a clear statement from the witness as the witness's confidence level that the individual or photograph identified as is the individual or photograph of the individual who committed the alleged crime. It appears that from the testimony that the court has heard thus far, that in showing the witness, Mr. Davis, these particular lineups, that there has not been the ability to locate the originals of these particular lineups that he was shown. He was shown 3 successive lineups. And the picture and the photo arrays and the composition thereof are not available at this point in time to the state or the parties or the court. So the state relies upon stage 3 and other documentary evidence that they've admitted for the court's screen grabs for the court's consideration to indicate that that this particular lineup was in fact presented in not an impermissibly suggestive way. The court shares the defense's concerns about the being able to weigh and being able to take a look at the pictures, as stage 3 is not a clear resolution of what was actually shown to Mr. Davis. It is very grainy. It is not clear, and despite the testimony of the witnesses that I have that the court has heard from, even Investigator Martin says that that the witness indicated, and this is what I have from my notes from listening and testifying, that zooming in makes the photos even more distorted. So using VTC in terms of the tool to even look at various pieces of the interview doesn't help with the resolution and a determination of whether or not these pictures follow the dictates of 17-20-2B2. Furthermore, the court does note from the photos in of itself that Mr. Stillwell, who was reportedly in stage 4, is the only person who has a tank top and the only person who has tattoos on his forehead. The second, and Ms. Love is correct in her assertion to the court that impermissibility indicates that the entity showing the particularized photos says, "Hey, pick me." So the court needs to go on to take a look at in the second issue, which is, if so, is there a substantial likelihood of irreparable misidentification? And to that, was the lineup impermissibly suggested? And then secondly, if so, was there a substantial risk of misidentification? Several factors, there are 5 factors that the court has to look at. One is the opportunity to view the perpetrator, the witness's degree of attention, the accuracy and level of certainty, which has been disapproved in Springer, and the court's not going to consider that. And also the length of time passed between the incident and the lineup procedure pursuant to Neal versus Biggers 409 U.S. 188, 1972. Now, the court is well aware that no Georgia case has had this particular set of facts. To that particular issue, the court has been presented some persuasive authority from other states, in particular Louisiana and Kansas, in which the failure to maintain a lineup per se is impermissibly suggested if the original lineup cannot be found. The state also asked the court to take a look at Daniel versus the state at 185 Georgia Appeals. I believe 228. Yes. 185 Georgia Appeal 228. And in Daniel, one of the driver's license photos used in the identification was missing at the time of trial, so the court had used a Xerox copy of the original photograph. And the argument was that the appellant argues on appeal that the law enforcement officers failed to preserve photos comprising pretrial lineup, and that there's a presumption that the display was impermissibly suggestive, which was not rebutted here. In this particular circumstance, one of the particular 6 photos was missing, but also the witness, who was the victim in this case, also I had an opportunity to take a look at the accused. So in combination, the court decided that this particular absence would go to weight more so than sufficiency, provided the pictorial lineup pictures. That is different than our case, and distinguished in our case where we don't have the original photographic lineups as required by 1722B2, as well as the video in stage 3 does not help in aiding the court in making that particularized determinability. Also considered for this was the matter of the case of Jacobs versus the state. Jacobs versus state can be found at 207 Georgia Appeal 714. And that particular matter, there were several series of identification. And in this particular circumstance, the state did not locate the original photographic lineup, which contained color photographs. So black and white photographs of the lineup were used at an earlier hearing. The defendant Jacobs objected to the admission, citing Daniel on the ground that the loss of the original gave rise to presumption that the state had not rebutted the original display was impermissibly suggested. So, an exhibit, the state goes to right, the court goes to right in Jacobs. The exhibit, although a copy of the original photographic lineup is not subject to the best evidence rule objection because it was primary evidence of the fact to be proved, and that the victim was shown a photographic display from which she identified Jacobs' picture as her assailant. The trial court found that the copy was of sufficient quality to enable the jury to assess her determination that the spread was not impermissibly suggested. We reviewed the exhibit and agreed. The challenge that we have in our case, going back to the court's earlier statement for the record, is that we do not have the original lineups, so we can't make a determination as the court did in Jacobs of the quality. The quality of stage 3 is unfortunately not very good, and we cannot test that against the original. So, and the originals have not been located as of yet. Additionally, in the facts that we have before the court, there's a picture of Mr. Stillwell only in one white. He's only one in one white tank top, and his particular background is similar from the other photos, and he has unique tattoos. It's unclear if any of the other people had tattoos from the photos or from stage 3, because we don't have the originals to make that determination. Now, in terms of opportunity to view, as is presented, Mr. Davis made this identification dark, saw it through the front windshield, got down the ground when the shooting started. He was about 60 yards away, so a yard is 3 feet, that means about 180 feet away for a couple seconds, and he only saw one side of the face, no eye contact. Then taking a look at the degree of attention, he got down to being shot. He got down to avoid being shot at, and as was testified, it was a highly stressful situation as a whole. The accuracy of the prior description: mid-20s to 30s black male, no tattoos, plaits sticking out about an inch. So, and there was some testimony about the context, claiming that the car stopped on the road and shot, opposed to being a drive-by. And then the issue of whether or not the car blinked its lights. And then the last thing the court has to take into consideration is the length of time that passed. It's over 26 months had in fact passed. So, in looking at both of the factors that the court has to look at, and that is the test for suppression, was the photographic lineup impermissibly suggested. The court has considered those particular factors as alleged already, but moves on to the biggers versus factors. And in taking a look at the totality of the circumstances, I'm going to find at this point in time that the lineup or I should say the out of court identification is in the totality of the circumstances impermissibly suggestive, and I'm going to go ahead, and it doesn't comport with Georgia law. In particular, it doesn't comport with 17-20-2B2, and I have taken into account that Section 3 does require the court to take a look at looking at it from a weight versus sufficiency standpoint. But given the differences in this particular case, I am not going as far as to adopt our colleagues from Louisiana's viewpoint that is per se impermissibly suggestive, but using the two-pronged test as set forth by our case, by our Supreme Court, I do find that it was impermissibly suggestive. Now, having said that, if you find the originals, they are made available to the defense and the court, I will once again revisit that particular ruling that I've made at this point in time, because I do think that would be something that the court would want to take a look at. Now, as for the in-court identification that Mr. Shard is concerned about, I'm going to wait until that particular Mr. Davis is poised to testify. I will ask the state to have me go ahead and then consider the factors as to whether, based on his testimony, whether or not you can lay a sufficient foundation to be permitted to him to testify about an in-court identification. I think that's premature at this point in time, but that's what I'm going to do at this point. So, Mr. Sharp, between now and next Thursday, the 12th of October, you need to prepare a suitable order for my signature and submit that to the colleagues across the state for their review and comment, and I will enter that as an order in this particular case. All right?
Your Honor,
Yes, ma'am.
would the court clarify, since there was no lineup where Mr. Davis identified Mr. Stillwell, can the court just clarify what the ultimate result of the ruling is in terms of what the state can and cannot do, and what the defense can and cannot do? What is it that we are prohibited from doing?
Well, that's up to you all. I mean, I think it depends on what you were trying to do at trial. So without more, I can't really comment on it.
Given that this was a motion to suppress an out-of-court identification, Is the state not permitted to show the video? Is the defense
You're not
permitted
you're
to
not
show the
supposed to show the video.
So it depends. Like I told you all earlier during this particular hearing, it also, I mean, I could see some other circumstances. You all are trial advocates. I am certainly not trying to try your case, but you all need to figure out whether or not I have, based upon what I've had in front of me so far, this particular identification is not admissible at this time. But it may be admissible for
No,
other purposes,
no,
depending on
Thugger,
what's
no.
seduced
The only
from
one he's
other
doing,
witnesses.
hold on.
So-
The only one he's doing tomorrow is
So
Mr.
you all
Steele,
may-
number 7.
as happens with
That's
some
it.
trials, inadmissible evidence admissible for other purposes if you go, go in that particular area of consideration. So without hearing more, without you presenting evidence, but at this point in time, the motion to suppress this particular identification is going to be, I'm going to go ahead and order it be suppressed at this point.
Suppress.
Like I said, if you come back with the originals, I'll reconsider the motion. Or
They don't have the original,
when it
Judge.
says
They
upon
said they don't
receiving
have
the name or
originals.
identification as to Mr. Davis, I'll do the outside the presence hearing of the jury. I'll make a determination, and then that you can if I find that it is proper, then you can present evidence on an in-court identification. Of course, I'm going to give the jury the particularized, should be relevant, instructions on how an identification is made.
Okay, so at this time, the court has made no ruling on substantial likelihood
Oh my God.
misidentification.
What?
Or-
I go on from there. No, I didn't stop it at prong 1. I'm excluding it because in the totality of the circumstances, both prongs have been, in my analysis of the court's.
I don't get it. He said it's suppressed. He said it's suppressed. Now, if you bring the original pictures that you claim you have, then he'll relook at it. But currently, right now, it's suppressed. That's what he just said. It's suppressed. It's suppressed. I know it's hard for her to not get a win on something, but it's suppressed. That's what he said, but he's still giving y'all his chance. Since y'all claim y'all don't know where the originals are, when you bring the originals in, he'll re-look at it, bring it up, and he'll go and review it. And if it lines up with according to what it should be, then he is going to allow it. But if it doesn't line up, if it's still showing the same stuff that it's showing now, it's still going to stay the same. Can you review why they have copies instead of original? Toya, they claim that they lost, they don't know where it's at. That's what they claim. They claim they don't know where it's at. But what happened is they don't want to show the original because there was some stuff written on it that I believe that was leading that person to say it was Stillwell. So that's why this is Sylvia talking. This is what I believe. I believe there was some shenanigan on the original and they trying to hide it. So it could have been a little note behind there. The picture said, okay, this is the one you need to pick, or whatever. Because the video doesn't show what's written on the back of it. So it could have been some stuff being done. I don't know. Possibility, allegedly, just a possibility. There's some notes that was written behind the picture. And now they make sure the picture disappear because what? It's going to show some leading and picking, that type of stuff. That's what You know, I that's what I believe. That's why how all of a sudden it disappeared, and all you got is a video. Original ain't right. Say it, Miss Sylvia. It's a lot of jacked up stuff going on with them. See, I just believe that something is on those pictures, like in the back of it, some like marking or something that they don't want the original to be shown, because all of a sudden the original's missing. They had the guy, remember, they had one of the individuals to step out while the DA guy was inside of there, Mr. Springer was inside of there leading, guiding the guy. So why the original picture is not shown? Why the original picture is not, well, how did it disappear? The original picture. They already did some shady stuff. They had the background different color from the one that Stillwell had. The clothing that the individuals had was dark, and they had t-shirts on. He's the only one that had on tank top. I mean, it was a lot of craziness that was done. Exactly, good. It's a lot of craziness going on. So my thing is, why is the original not here? Why are they relying on a video and not the original? And why is the video grainy? Come on, all the videos they have and those other videos is good picture. How come this is grainy and look distorted? Now, this is the government. They have great equipment. They can purchase great equipment. And I'm definitely not a conspiracy theory person, but there's some strange stuff right there. There's some strange stuff that's not right. And okay, y'all, why no cameraman is there? Why they keeping me out the courtroom? You got to ask those questions, these tough questions. Why? You see, they didn't expect somebody to still be going every day and still showing up. You get what I'm saying? They didn't expect that. They expected me to be giving up, but I haven't given up. Exactly, Sierra. And they make it tough, but they make it subliminal toughness for me. But and they make it as hard. They make it where, you know, I would get frustrated and just give up. Y'all know I've been through the trenches with a lot of stuff. It's a lot of stuff that's going on. I never thought about corruption and dirty and weird tactic. I really thought that the justice system was at least going to do things fairly, but I see not. That's why I say I don't take things as it is. You know how some people say, oh, it's a person got a whole bunch of charges and stuff like that. I can't, I'm sorry, yeah, I can't just go and say, oh, this person's guilty because of what they're putting out. I can't do that anymore. I can't, because the stuff that I've seen in a lot of different cases, I can't. I can't. Tall glass. I have an attorney that well, I'm tagging along with George Cheedy. He has gotten an attorney, and it's a couple of us that's gone together in the filing for me to be able to be in the courtroom. So I'm fighting that. The motion is going to be submitted. You're going to see the motion. I'll be reading that motion once the attorney submits it for me to be able to get in the courtroom. And because even today, y'all, when they was doing the testimony, the prosecutor had her mic off. I couldn't even hear. I couldn't even hear what was going on. So I do have the recording from the last person that they interviewed this morning, but I really couldn't hear. I couldn't hear it at all because if they have the mic turned off, there's no way you can hear it in the overflow. I told you today, Sylvia, you will walk indoors that no man will close. Keep going and keep God with you. Never lay down, always stand up. Thank you, Tasha. Thank you. Thank you. Thank you. I know. I know tall glass. I know. But to me, I mean, and in fact, y'all, I saw Judge Cox today. He's the judge that's going to be over YFN Lucci, and I told him that I submitted Rule 22 in his case, and he told me to resubmit my Rule 22. So, and he told me there's another hearing coming up, and he gave me the date for the hearing. So I'll be back doing YFN Lucci as well. So, but hold on, let me finish. Use it at the full potential. You can't use it. You can't use it to fullest potential. Hold on a second. Let me finish this off so y'all can hear what she asked the judge, okay?
Of misidentification exists. Factors for evaluating the likelihood of irreparable misidentification due to an impermissibly suggested out-of-court identification procedure include: 1, a witness's opportunity to view the accused at the time of crime; 2, the witness's degree of attention; 3, the accuracy of the witness's prior description of the accused; 4, the witness's level of certainty at the confrontation; and 5, the length of time between the crime and the confrontation. Whether a witness knows the defendant is a critical factor in determining the reliability of an out-of-court procedure. The court has also taken into account OCGA 17-20-2B2, enacted, I believe, in 2016, wherein it references no later than July 1st of 2016. And this interview occurred after 2016. Any law enforcement agency that conducts live lineups, photo lineups, or show-ups shall adopt written policies for such, using such procedures for the purpose of determining.
Sorry, y'all.
The exhibit, although a copy of the original. A tally of the circumstances, I'm going to find at this point in time that the lineup or I should say the out-of-court identification is in the totality of the circumstances impermissibly suggestive, and I'm going to go ahead, and it doesn't comport with Georgia law. In particular, it doesn't comport with 17-20-2B2, and I have taken into account that section 3 does require the court to take a look at looking at it from a weight versus sufficiency standpoint. But given the differences in this particular case, I am not going as far as to adopt our colleagues from Louisiana's viewpoint that is per se impermissibly suggestive, but using the two-pronged test as set forth by our case, by our Supreme Court, I do find that it was impermissibly suggestive. Now, having said that, But the state, if you find the originals, they are made available to the defense and the court, I will once again revisit that particular ruling that I've made at this point in time, because I do think that would be something that the court would want to take a look at. Now, as for the in-court identification that Mr. Shard is concerned about, I'm going to wait until that particular Mr. Davis is poised to testify. I will ask the state to make to have me go ahead and then consider the factors as to whether, based on his testimony, whether or not you can lay a sufficient foundation to be permitted to him to testify about an in-court identification. I think that's premature at this point in time, but that's what I'm going to do at this point. So, Mr. Sharp, between now and next Thursday, the 12th of October, we need to prepare a suitable order for my signature and submit that to the colleagues across the state for their review and comment. And I will enter that as an order in this particular case. All right?
Your Honor,
Yes, ma'am.
would the court clarify, since there was no lineup where Mr. Davis identified Mr. Stillwell, can the court just clarify what the ultimate result of the ruling is in terms of what the state can and cannot do, and what the defense can and cannot do? What is it that we are prohibited from doing?
Well, that's up to you all. I mean, I think it depends upon what you were trying to do at trial. So without more, I can't really comment on that.
Given that this was a motion to suppress an out-of-court identification, is the state not permitted to show the video? Is the defense not permitted to show the video? Can the court just?
So it depends. Like I told you all earlier during this particular hearing, it also, I mean, I could see some other circumstances. You all are trial advocates. I am certainly not trying to try your case, but you all need to figure out whether or not I have, based upon what I've had in front of me so far, this particular identification is not admissible at this time. But they may be admissible for other purposes depending upon what's deduced from other witnesses. So, or what is said or attempted to be said. So you all can make, as happens with some trials, inadmissible evidence admissible for other purposes if you go in that particular area of consideration. So without hearing more, without you presenting evidence, but at this point in time, the motion to suppress this particular identification is going to be, I'm going to go ahead and order it be suppressed at this point. Now, having said that, like I said, if you come back with the originals, I'll reconsider the motion. Or, depending upon what is testified, if you're seeking to get an in-court identification as to Mr. Davis, I'll do the outside the presence hearing of the jury. I'll make a determination, and then that you can if I find that it is proper, then you can present evidence on an in-court identification. Of course, I'm going to give the jury the particularized, should be relevant, instructions on how an identification is made.
Okay, so at this time, the court has made no ruling on substantial likelihood of misidentification, or
I go on from there. No, I didn't stop it at prong one. I'm excluding it because in the totality of the circumstances, both prongs have been, in my analysis and the court's analysis, they're impermissibly suggested.
and it is the 6-pack array that we don't have.
You don't have any of them.
Right, that's what I'm saying, is that that is the it that is being suppressed?
I'm suppressing that whatever is in that video, unless you come up with the originals or you have some other, you have none of your witnesses been able to testify to God office. And I think your case is much different than any of the other cases because you don't have anybody necessarily that can identify these particular or make the identification process so it can be weighed. And I don't think you followed through with 17-20-2B2.
And so, given the report you said, this person was in the video, to support me, the video itself, the contents of the video, or just the photos, lineups that were captured in the
That
video?
depends. It may be useful for other purposes. All right? So, Mr. Sharp, prepare a suitable order, send that to your colleagues across the way. Remember, I made this ruling, I made this ruling. It is subject to change depending upon if the originals are located.
Yeah.
Or it may be utilized it may be admissible for other purposes. The only thing I'm going to suppress this one time, Mr. Sharp, is the lineups themselves, okay? So the tape might be useful for other purposes, and it just depends, okay? All right. Okay, let's move on to some other business at this point in time. I'll put on my calendar here. Sure. I don't want you to do that. It's too much of a problem. Mr. Stillwell, do you have an issue with Mr. Sharp excusing himself to take up another matter, sir? Okay, all right, then yes, sir, you may. Okay. Do you need it? Yeah. Yes,
While we're transitioning, can I step out for comfort?
you can. I'm going to go ahead and get started, okay?
Yes, that's fine.
All right. Mr. Randolph, do we have juror 394 available, sir?
It's done.
Okay, let's go ahead and call in juror 394.
All right, yeah, I'm gonna end this now, but that's it for that was the motion. And I'm gonna go ahead and end this live. So tomorrow they're gonna do they're gonna hear Doug's motion number 7. Let me see what motion number 7 was. Hold on a second. My computer, I have so much stuff on my computer, it's ridiculous. It's like I gotta label them where I can understand which one is which. Let me look for it. I'm gonna pull it up from there. What's the name? Yes, on Monday, and still haven't got nowhere this witness list is going is something. No, thank you. I am just over here sick of the judicial bias. Tall glass. I agree with you. I agree with you. Tall glass. I'm going through something right now. I'm gonna talk to you guys later once I finish my motion and all this stuff. But I'm dealing with the unfairness of the justice system right now for myself. I'm dealing with that right now. People can lie, people can make up stuff, and take you to court, and you stuck with trying to redeem yourself. And I always say, whenever someone take you to court, you already lose. Even if you win, you already lost. Because it's the time, the energy, the finances, and all that stuff that you got to go through to get out of the situation, You're already in the loss. You fighting too? I'm sorry. Wow. It just gets on your nerve, right? It just really like, I don't know. It's very sickening. It's very sickening. It's draining because it's like it takes so much of your energy. You know what I'm saying? It takes so much energy. And if you forget, if you decide not to fight, thank you, Sharon. If you decide not to fight, then they get judgments and all this kind of stuff. But, it's draining because I'm trying to do this work here, but every time I turn around, it's something. It's something. It's something. It's something. I want to show you something. Hold on a second. No, I'll show you another time when I talk about my stuff. I don't want to mix up these other what we're talking about with this. I'm sorry, I'm yawning, but I'm gonna have to go to bed. So you guys have a good night. Thank you for the prayers, Sharon. Good night, everybody. I'm sleepy now. And I gotta get up early in the morning. Good night.